Hi, thank you for meeting with me. I wanted to go ahead and meet so that we can discuss and explain your procedural safeguards as a parent. First, I wanted to go over why procedural safeguards must be reviewed, and that's to ensure that parents fully understand their rights, responsibilities, and options available to their child. This helps parents to advocate effectively for their child. Participating meaningfully in decision making, resolving disputes, and staying informed about changes are the main reasons why we review the procedural safeguards. Now, as regards to parent and or guardian participation, collaboration is key. Parent guardian participation is essential for collaboration. Parents provide crucial input, and parents have legal and ethical obligations. But we want to uh, empower parents for advocacy. Now to discuss access to educational records. Parents have the right to access educational records. It's a fundamental part of the IDA. You have the right to access records in a timely manner, free of charge. And this includes records such as IEPs, evaluations, assessments, progress reports, disciplinary records, and communication between you and the school. Confidentiality of information. Confidentiality of information is essential for safeguarding the rights of children with disabilities. Parents have access to their child's records, but this access is protected by confidentiality guidelines to make sure identifiable information is used appropriately. Now, to go on about informed consent, which is also parent consent. Informed consent ensures that parents or guardians fully understand the decisions being made about their child's education and the services that they're receiving. It is required for evaluations, reevaluations, initial IEPs, any changes to the IEP, and release of educational records. And it must be in written consent. The school must provide support if there is difficulty in understanding it as well. I also want to discuss prior written notice. This is a written document that schools must provide to parents whenever certain actions are proposed or refused concerning the child's IEP. PWNs or prior written notice must be given before making any changes to educational services, before refusing to provide services, when proposing to evaluate or reevaluate for a triennial, and when proposing to change the child's placement. Remember that a notice must be given at least 7 days before the proposed action. I also want you to know about understandable language. This is when you are being talked to in a very clear and simple and straightforward way. We're going to provide clear descriptions, use everyday examples, and be direct and to the point. Make sure that explanations of next steps are clear. This is important to empower you as a parent and to ensure trust and provide clear communication. Now, independent educational evaluation. When a parent requests an outside expert to evaluate their child's educational needs if they disagree with the school evaluation, you might want to request one if you disagree with the results, you want a different perspective, or you want more information. This must be in writing. The school must either pay for it or give an explanation in writing why they think the school evaluation is appropriate. If that does not work, a due process can be asked for. You also have stay put rights, and this is rights protected under the IDA. These rights ensure that your child continues to receive certain services and their current educational services if there's a disagreement between you and the school. Simply put, if you guys can't agree, then your child stays put at what they're doing. Stay put's important because it ensures continuity of services, protection against sudden changes, and it gives you peace of mind. Now, discussing resolution options. Before jumping to a formal dispute resolution, it's a good idea to start with communication. Try talking to the teacher, meeting with the IEP team, collaborating and keeping notes of any meetings or conversation is very important. If that doesn't work, then you have to go to other resolution options, such as mediation, which is voluntary and informal, but this is when a third party or a mediator comes in and helps to find a solution. There's also due process hearing, which is formal and a legal procedure. This is similar to a court trial, but focuses on your child's needs. Both sides present their evidence, they call witnesses, and they explain their sides. You can bring an attorney or an advocate. There's also state compliant procedures. This is if you feel that the school is violating the IDA or not following your child's IEP. This is a formal state complaint, and the state will investigate and respond to you in a written manner. Now, there are also resolution meetings, which gives you a chance to resolve any issues before due process hearing. If you have any information that you have questions about, please contact me or any of the IEP team because we are all here to assist. I want to also give you two parent resources that provide additional information on procedural safeguards. One is Rights Law, which is a website. It's www.rightslaw.com. And this is a website that helps parents and advocates understand special education laws. It includes books, articles, and training materials. There's also another website that I would like to recommend, and that's Center for Parent Information and Resources, CPIR. The website is www.parentcenterhub.org. This is a great website for parents and it focuses on special education rights and procedural safeguards. It also includes free downloadable resources and parent friendly toolkits. If you have any questions about your parent rights, your procedural safeguards, please reach out to anybody on the team or reach out to me. You can call me or you can text me or you can email me. Thank you for your time, and I'm glad that I was able to share all of this information about procedural safeguards.